One is to identify issues in dispute. Next would be to set a hearing date and briefing schedule for resolution of the issues. Third would be to determine whether in-camera review is likely to be needed, and if so, how that would occur. And then any other issues, including whether mediation is appropriate. So I did review Mr. Thomas's complaint. I did review, Ms. Steele, your answer. I also reviewed a pleading that Mr. Thomas filed on the same day, I believe, as your answer, which was a declaration entitled Joe Thomas's Declaration in Support of Withholding Log. And so I understand at least all of those issues. Do either of you want to take a crack at the issues that are in dispute? Have you both talked?
We have not, well, we've spoken on the phone several times. The issue stated in the complaint is withholding log.
Correct.
That's the only issue.
And it appeared that the correspondence that Mr. Thomas's declaration addressed, at least as I understand it, some of the issues with that withholding log. Is that accurate?
Yes, the withholding log was inadvertently not attached to the cover letter, which is now in the record. That was produced 2 weeks prior to the filing of this complaint. So there is something in the complaint that we denied because we did produce it prior to the filing of the complaint. But that remains the only issue in dispute in the complaint, which is not a denial of records if we want to get into the meat of stuff now. But that is the only issue that's in the complaint. So, if we're talking scheduling and what's going to be occurring, I think it would move very quickly to a motion for hearing on affidavits and set the timeline very, very briefly because that's the only allegation in the complaint, and under 550 of the Public Records Act, it's not a denial of records. So.
Thank you, Ms. Gill. Mr. Thomas, do you agree with the characterization of the issue and the fact that this matter could be set on a relatively quick schedule?
I agree with the issue. I think there's a concomitant issue, a secondary issue. So there's an issue of whether, now that we know what the redaction log is and what legal basis, if there is any, that the Attorney General is claiming for these redactions or these withholdings, there's an issue of whether these legal justifications are sufficient or lawful. And this was done after the lawsuit was served to the Attorney General's office. And so if the Attorney General's stance is that there's only one issue in the complaint, then we may need to amend the complaint in order to address this secondary issue of if there's a sufficient basis for these withholdings, because this is what Mr. Green wanted. He wanted these calendars, and it's not sufficient for the Attorney General's office just to give them the Mr. Green redacted, even with the withholding law. There are several that seem, for example, the dentist appointment that was put on an official work calendar. That's listed in the complaint, that the Attorney General went to, I believe, on August 17, 2017, to the dentist, it appears, and there's redactions listed with the dentist, and that was a part of his official business. It was on his official calendar, but during our phone conversations, or one of our phone conversations, I believe it's the Attorney General's stance is that they don't have to redact that. So then there's questions of the sufficiency of some of the redactions now that we have a redaction log.
Ms. Steele?
Your Honor, that's not it's not alleged in the complaint as a violation. They did have the log prior. We were served with the complaint. The timeline that he set forth is correct. We were served with the complaint. We immediately clarified the clerical error. They had the log for 2 weeks and filed the complaint with only the failure to produce the exemption log in there. what he's describing is accurate, but the complaint currently only alleges the violation of the failure to provide the log.
And I
So
think Mr.
if
Tom-
there are additional issues, I do think that an amended complaint is necessary, but I would still urge for a quick timeline for briefing.
Well, I think Mr. Thomas basically agreed with you, Ms. Steele, regarding the current state of his complaint and the issue that leaves the court. I'll leave it to the parties to determine how they proceed regarding any other issues. But as I understand it, there's just this one issue currently. And so, it did not appear to the court that in-camera review was going to be necessary. Is either party requesting in-camera review?
No, Your Honor.
No, Your Honor.
Well then, the next available date that I have for a hearing would be April 19th. Is that acceptable for the parties?
That sounds very good, thank you. For a final motion hearing on affidavits.
Correct.
Yes, Your Honor.
So then, that means the filing and service of the
I'm
petitioners.
sorry, Your Honor. That's a Friday, and I believe I'm actually out of town. That's the only Friday I'm out of town in April.
Well, I had good luck picking that one Friday. Then.
I just realized that it's.
That's
great.
okay. Fortunately, we could go April 26th.
Thank you, yes, that's fine.
That works for Ms. Steele. Does it work for Mr. Thomas?
Yes, Your Honor. I would just like to say that if we're adding the secondary issue, I would just ask the court to recognize that we may run into problems. And I anticipate we won't, but.
Well, this date might work better than.
Yes,
for
yes, Your Honor. Thank you.
that concern. So April 26th would be our hearing date. That's at 9 a.m. And then the filing and service of the petitioner's brief would be March 29th. The filing and service of the respondent's brief would be April 15th. And the filing and service of the petitioner's reply brief, if any, would be April 22nd. So, I guess I always encourage, and I appreciate that you both have alluded to phone conversations that you both have had. I would hope that you would be able to continue talking and hopefully come to some sort of resolution. But if not, we have this hearing date, and that's when the court will make its decision. The way I view these, and Mr. Thomas knows because he's appeared in this court before, and Ms. Steele, you may have, but I don't recall on a public records case that you have. The court views that hearing as a merits hearing, that I'm deciding whether or not there's a violation of the Public Records Act. If the court found that there was a violation, then there would be a subsequent hearing set where we would talk about what penalties, costs, and fees would be appropriate.
Your Honor, are you open to having both of those on that same day, given that?
Thank you. So, I would ask the parties to be able to put together a order that contains those dates and the issue that you both have outlined. And I don't imagine that could occur today. I see Ms. Steele nodding. Mr. Thomas, I think, is also agreeing. That can be handled ex parte. It could be by mail or in person on ex parte. Or if the parties do think they can work on that now, it could certainly be presented this morning. Or it could be presented on any Friday morning, the beginning of my civil calendar. So does either party have any other questions or concerns?
No, thank you, Your Honor.
No, Your Honor.
Very good. All right, well, I look forward to seeing you all back before me, and have a good weekend.
Thank you, Your Honor.
You're welcome. Well, it's one of those surprising Friday morning calendars.